Let's talk a little bit about King v. Burwell, the Supreme Court case that was in the news for upholding Obamacare. But what I want to show you is that the case wasn't really about Obamacare, and was about the proper way to read a law. And bottom line, if there's more than one way to read a law, but one of those ways makes it so the law works the way Congress intended for it to work, then that's the way you're supposed to read it. The Patient Protection and Affordable Care Act, Obamacare, is a major piece of legislation designed to bring down uninsured rates in America. Because in America, no one is ever really uninsured. Under this law called EMTALA, the Emergency Medical Treatment and Active Labor Act, hospitals cannot leave people to bleed out just because they can't pay. Instead, they have to treat them. Then they bill and bankrupt them. Hospitals don't get paid, so they have to charge the rest of us more to make it up. So ultimately, uninsured really means rest of us insured. Obamacare starts with, anyone who wants health insurance can get it. Oversimplified, health insurance companies collect premiums from a pool of people and use them to cover their healthcare costs. Whatever's left over is the insurance company's profits. A couple people in a pool getting really sick can significantly increase the entire pool's healthcare costs. So to protect profits, insurance companies are notorious for kicking people off or denying coverage for getting sick, or for charging sick people prohibitively higher premiums. It's the story of the guy who paid premiums out of pocket all his life, only to get cut off when he got sick. This used to happen all the time, but Obamacare put an end to it. Insurance companies cannot do that anymore. But this law doesn't work on its own. You know why? Because it creates the exact opposite problem. Why pay for health insurance when you're healthy if you can get it for the same price when you need it? But fewer healthy people in a pool increases the pool's average healthcare cost per person. So insurance companies raise rates to protect profits. But rising rates cause more of the healthier people to put off paying for healthcare. So rates rise even higher, and this cycle continues until the market's dead. That's why they call this the death spiral. It happened in Washington in 1993. States said anyone who wants health insurance can get it, and for the same price as everybody else. By 1996, premiums in the state had increased 78%, while enrollment declined at 25%. And by 1999, 17 of 19 insurers had left the state. The insurance business doesn't work if they're only covering sick people. Obamacare keeps healthy people in the pools by making health insurance mandatory for anyone who can afford it. And health insurance is affordable as long as it costs less than 8% of income. But health insurance is expensive. Something like half of taxpayers don't make the 8% cutoff. For example, it would be too expensive for someone making $10 an hour, working 50 hours for all 52 weeks, because that's $26,000. 8% is $2,080, or $173 a month. Health insurance costs more than that. So even at 8%, there are too many millions on the outside looking in to prevent a death spiral. Obamacare gets these millions under 8% by giving them tax credits to help them pay for healthcare. Oversimplified, take the guy making $26,000. $225 premiums would be too high, but a $52 tax credit gets him back to 8% and puts him back in the pool of people covered. Obamacare tax credits can only be applied to health plans purchased through what's called an exchange. An exchange makes health insurance available to what's called qualified individuals. And a qualified individual is someone who lives in the state that established the exchange. Each state was required to establish an exchange. 42 United States Code, Section 18031. But Congress didn't count on state cooperation, because the goal was to lower uninsured rates in America, not just in those states that were willing to help. So Congress put in the law a provision, 42 United States Code, Section 18041, that says if either a state refuses to set up an exchange, or if the federal government decides the state's not going to get it done on time, then the federal government's going to set it up. Either way, there will be an exchange for the people in the state to compare premiums and purchase plans. Tax credits are paid directly to insurers. Do you know what this case, King v. Burwell, was about? The argument, this decision, whether the state or federal government sets up the exchange, determines whether or not Obamacare works in the state. Petitioners David King and 3 others live in Virginia, and they do not want health insurance. but with tax credits it costs them less than 8%. Their argument is that they shouldn't get tax credits because the state of Virginia refused to establish the exchange in Virginia, so the federal government set it up. But Title 26 United States Code, Section 36B, Sub B, Sub 2, Sub A, says the amount of the tax credit is based on premiums for health plans enrolled in through an exchange established by the state. Therefore, their argument is that the amount of tax credits in any state where the federal government sets up the exchange will always be $0. The Supreme Court basically said, oh, give me a break. Congress passed the Affordable Care Act to improve health insurance markets, not to destroy them. And the court will not undo a major piece of legislation over inartful drafting, because there's no reasonable way to believe Congress meant for this decision to be that important. If it were, they would have found a way to make it clearer, like maybe say something about it somewhere and not bury it in a sub-part of a section that's not even talking about exchanges. It's talking about tax credits. But really, you would expect something about it here, where the law talks about the federal government stepping in to set up the exchange. Like, oh, by the way, if it does, Obamacare will fail in the state. There's nothing to even suggest anything like that here, because the way it works is the federal government is stepping in to set it up in the state's place. All the same rules apply. And you know, other parts of Obamacare are also a little loose with words. Inartful drafting. For instance, an exchange is only for qualified individuals, which is defined as someone who resides in the state that established the exchange. But when the federal government sets it up, it's obviously not for no one, right? The people in the state are qualified individuals, even though no state established the exchange. No one even argued otherwise. Now, Obamacare does not work without tax credits. It leaves too many people on the outside looking in to avoid a death spiral. Failure is inevitable. The only way to convince yourself that that's how Congress meant to set things up, that they wrote certain failure as an option into the law, is to look at just this one sentence, ignoring the rest of the 906-page law. So when you boil it all down, this is a nitpick, the kind you can probably find in any major piece of legislation. The Supreme Court saying, given everything that goes into making a law, once a law's been made, if the question's not about constitutionality, but about how you're going to read it, the court will read it so that it works the way Congress clearly intended for it to work. The court will not nitpick it apart until it's found a way to read it so that it fails. And that goes for every law. That's not just about Obamacare. But somehow this case was all about Obamacare, wasn't it? To those who we know have been trying to get rid of it. But now that you know what the case was about, you tell me, doesn't the decision make sense? And whether or not you agree with it, could you call it judicial activism? Me, personally, I don't even think there's a good argument for it. As always, thanks for watching. Please subscribe if you learned something. And until next time, take it easy, everyone.